could have lasting negative.
So I urge my Republican colleagues to consider before voting to confirm tonight the very real impacts their actions will have, before voting not only on millions of our constituents, but the very real impacts their actions itself. Not only on millions of our constituents, I will be voting no on the confirmation of Judge Barrett. As for me, to the United States, I will be voting no on the confirmation. Thank you, Mr. President. With that, I yield Judge Barrett to the United States Supreme Court. Thank you, Mr. President. With that, I yield the floor.
The senior senator from Texas.
Mr. President, that was quite a speech from our
The
friend
senior
from
senator
Delaware.
from Texas.
I'd have to,
Mr.
if I had to
President,
categorize it, I'd say this is really the Chicken Little argument. Delaware. The sky is falling. Amy Coney Barrett, this is the end of civilization. This is the end of the world as we know it. The irony to me, and frankly the hypocrisy of the argument, is that if the shoe were on the other foot, Senator Schumer, who has said everything is on the table if we win the majority, court packing, making D.C., making Puerto Rico states, that they would somehow show this superhuman self-restraint and not fill this seat. Mr. President, this is entirely consistent with the practice, given the fact that the President Trump's term, his first term, doesn't run out until January the 20th of next year. All the senators elected are serving through the end of this year, at least. And so it is somewhat entertaining, but beside the point, to suggest that this good judge, this really extraordinarily decent human being, is part of some vast conspiracy to subvert the Constitution and overrule all these precedents that the senator from Delaware considers sacrosanct. Well, I'm happy with the fact that tonight the Senate is set to confirm an exceptionally well-qualified nominee to the Supreme Court. Judge Amy Coney Barrett is as impressive as they come. America saw it. Initially, they didn't know her, but when they came to know her through her testimony on the Judiciary Committee, she became very popular. In my state, 59% of the people in a recent poll said they wanted us to confirm Judge Barrett now, before the election, 59%. And it's no wonder why. She graduated first in her class from Notre Dame Law School. She clerked for the District of Columbia Court of Appeals and the Supreme Court, practiced law before transitioning to academia, where she has written and wanted us to taught constitutional law, federal courts, and statutory interpretation for nearly two decades. And of course, for the last 3 years, she served with distinction on the Seventh Circuit Court of Appeals. Her time in both the classroom and the courtroom have given her understanding of the law that few can rival. Over her confirmation hearing, she skillfully answered questions about legal doctrine, constitutional issues, and myriad precedents without so much as having a page of notes in front of her. As impressive as Judge Barrett's deep knowledge of the law is, that's only part of what I believe makes her an ideal candidate for this Supreme Court. Now more than ever, the judiciary, along with the rest of our other elected officials, tend to function not by what the law says, but through a lens of personal and political bias. It's polarizing. We know that people are highly agitated, including my friend from Delaware, and trying to stoke the turnout of their partisans in the run-up to the election. But it should go without saying, but I'll say it anyway, that judges don't do that. They can't do that and still be judges. In order for the High Court to serve the proper role under our Constitution, it has to be made up of men and women of great integrity, of restraint, and self-discipline, who will discharge their duties on the bench free from bias, which means you don't announce the decision in a case before you've even heard it. You don't offer predictions or promises of how you will decide these contentious matters, which I know frustrates our friend from Delaware and others. But Judge Barrett is not only committed to doing this, not clouding her decisions by personal or political motivation or favor for any party. She has a record to back it up. During her time on the Seventh Circuit, she has joined with her colleagues in 95% of the 600 cases she's decided. 95% consensus on the three-judge panel. That's no record of an outlaw or a radical or somebody who's going to disregard their judicial oath. She has consistently shown in each of these decisions a fidelity to the law and an impartiality, which are essential qualities for a Supreme Court justice. But despite the judge's unassailable qualifications, our Democratic colleagues have repeatedly tried and failed to make this nominee out to be a radical, suggesting that she would violate her oath, the same oath to uphold and defend the Constitution that we take as senators. But there's nothing in her background or her character which would suggest she would do something so brazen and so wrong. Some folks on the left have attacked her because of her Catholic faith. They've also tried to convince the American people she's on some sort of crusade to take health care away from American families. How ridiculous is that? Or that she would slowly chip away at our freedoms and our liberties. The reason we've seen such hysterical attacks that are completely out of touch with reality is that this is all they have. They've got nothing else. There is no legitimate reason to oppose the nomination of Judge Barrett. Her stellar credentials and deliberate body of work prove that she understands the role of a judge, as important as it is, but as limited as it is under our constitutional system. And I think that is part of what terrifies our colleagues on the other side of the aisle. You see, they become accustomed to a Supreme Court that is more political than judicial, that feels free to make policy judgments, to bail out the Congress or those who have either lost the vote or lost an election. That's why our Democratic colleagues have repeatedly pressed her to commit to an outcome in cases before the court. She won't do it, and she shouldn't do it. And she didn't do it. They ask her everything from health care to abortion to climate change. They want to know right now, before she's even on the court, before she's even heard the case, how she would rule. Well, Judge Barrett rightly declined. She invoked what's known as the Ginsburg Rule from the 1993 confirmation hearing presided over by Joe Biden when he was chairman of the Judiciary Committee of Ruth Bader Ginsburg. Now, Ruth Bader Ginsburg had been a lawyer with the American Civil Liberty Union and been known for her pioneering work on behalf of women's rights. But she held some personally pretty radical views. And so the senators, out of curiosity, if nothing else, wanted to ask her about those. And she declined, as she should have, because she said it's inappropriate to make predictions or provide hints of how I might decide cases in the future. This is the most basic principle of our judicial system. Judges are not legislators. They shouldn't advocate for policy outcomes or promote a specific agenda, and they certainly shouldn't commit to an outcome on a hypothetical case during the confirmation process. How would you feel if the judge who you came before had previously said, well, if I hear a case like that, I'm going to decide against this litigant, this party to the lawsuit? That would be outrageous. And she shouldn't and didn't do that. Neither did Justice Ginsburg. Chief Justice Roberts reminded us last year, we don't have Obama judges or Trump judges or Bush judges or Clinton judges. And I agree that is the ideal. Men and women in black robes can't stick their thumb on the scales of justice and supply wins to any cause, any individual, or any party. It's antithetical to our constitutional system. So I hope this process will help begin a way to guide our courts back to their proper function in our Constitution, and to remind all of us of what has rightly been called the crown jewels of our Constitution, and that is an independent judiciary. Judges whose pay can't be cut during their tenure in office, and they serve for life if they want to. That's the ultimate in political independence. Those are the crown jewels, because judges apply the law that the Congress writes, interpret the precedents of other courts, and interpret the Constitution. To give an unelected individual the power to make policy and to have an agenda to accomplish their personal or political goals would be the opposite of what our Constitution comprehends. So there's no question that Judge Barrett has a brilliant legal mind, a deep respect for the Constitution, and an unwavering commitment to the rule of law. Her resume and her record are spotless. How do I know that? Well, if it wasn't, you would have heard about it. It's spotless. Her character is beyond reproach. And virtually everyone who's worked with or learned from Judge Barrett has offered their full-throated endorsement of her nomination. All the evidence points to one simple fact. Amy Coney Barrett is exceptionally qualified to serve on the Supreme Court. I have faith in Judge Barrett's ability to fairly interpret the law and apply it to cases before her. Nothing more and nothing less. Mr. President, I believe Amy Coney Barrett will be an outstanding Supreme Court justice, and I'm proud to support her nomination.
Mr. President.
The senator from Illinois.
Mr. President, we're faced with three basic questions. And the first question couldn't be more basic. Why are we here? If you told the American people that the United States Senate was in session 5 days in a row and meeting through the weekend, and asked them what they think the order of business was before the Senate, they would say, silly question, it's obvious. It has to be the pandemic facing America. It has to be the fact that 225,158 Americans have died from the coronavirus, 8.7 million infected, and most certainly because the United States has recorded more than 85,000 COVID-19 cases just this last Friday, the highest number of cases recorded within a 24-hour period since the beginning of the pandemic, and Saturday was the same. So they would guess that the United States Senate was in session to do something about this deadly epidemic that is affecting the United States of America in a more serious way than any country in the world. They would wonder what we're doing to try to provide more testing, more protection for people. They certainly would question the statement by the Chief of Staff of President of the United States, Mark Meadows, who said just yesterday that the Trump administration, quote, is not going to control the pandemic, end of quote. It would trouble them, I'm sure. They would expect this Congress, representing them and up for re-election, many of us, to be responsive to their needs to protect their families. Or they might ask us, are you doing anything to help the people, the 23 million unemployed in America? Certainly you must be working on that too, because these families were cut off from their federal unemployment supplemental on July 31st. So for the months of August and September, and now into October, the amount of money coming in to keep their homes together, their families together, has been dramatically diminished. If they assume that, they're wrong, because for the last 5 days here in the United States Senate, we have not been consumed with those life and death issues of this pandemic at all. Instead, we are consumed with a political mission. How did we reach this point where we're taking up this Supreme Court nomination in the midst of a presidential election for the first time in the history of the United States, in the midst of an election that we were taking this up? Well, because of the determination of the Republican Majority Leader in the Senate, Senator McConnell of Kentucky. 4 years ago, you'll remember the Anton Scalia vacancy. President Obama decided that he was still president of the United States in the 8th year of his presidency. But Senator McConnell said, no, you're not. You do not have the presidential authority to fill a Supreme Court vacancy because it's the last year of your presidency. You're a lame duck. There's an election coming. Let the American people decide who will fill this vacancy. That was the McConnell rule 4 years ago, and the Republican senators marched in lockstep behind him with his logic. Fast forward 4 years. Vacancy with the death of Ruth Bader Ginsburg, and Senator McConnell has changed his story completely, and his troops are still marching obediently behind him. Now, under President Trump, he can fill a vacancy even in the midst of a presidential election. And that's why we're here today. This determination by Senator McConnell that this political errand that he's running for President Trump is more important than the COVID-19 pandemic, more important than the runaway infection rates in 20 states across the United States, more important than trying to deal with the unemployment and the dysfunctions of this economy under this president. Yes, we were asked basic questions to be answered by the Judiciary Committee, questions that were posed to Amy Coney Barrett, once a law school professor at Notre Dame Law School, now on the Seventh Circuit Court of Appeals. People say, is she qualified? Well, if you're asking whether she is studied in the law and has a head full of law, there is no question about it. It's been many years since I faced a law school professor, and I will tell you that she certainly knows a lot about the law. There is no doubt about it. But the questions that I asked of her really went beyond that basic question. I really wanted to know what was not just in her head when it came to the law, but I wanted to know what she has in her heart when it comes to the law. One of the senators who spoke a few minutes ago chided us because we kept bringing color photographs to the floor and to the committee hearings of people whose lives depended on the Affordable Care Act. He characterized it as theater and likened these images, these photographs, to cutouts at sporting events. Well, let me tell you, the ones that I presented from Illinois represent real-life stories of real-life families who depend on the Affordable Care Act. Why do we raise the Affordable Care Act in the midst of this hearing for filling this Supreme Court vacancy? For one simple reason. That's what the president did. It was the president who told us far in advance, I'm going to fill Supreme Court vacancies to eliminate the Affordable Care Act. So is this a leap of faith on our part to take the president at his word? Would the president even consider lying to the American people? If you take him at his word, then Amy Coney Barrett is part of an agenda. a political agenda to eliminate the Affordable Care Act, and in the past the president said Roe versus Wade while you're at it, and also to move forward when it comes to protecting him if there's an election contest after the November 3rd election. He said as much. As I mentioned earlier, he doesn't have an unuttered thought. He tweets it 25 times a day, whatever crosses his fertile mind. And that is his agenda when it comes to filling the Supreme Court vacancy. When we ask Judge Barrett, she denies any promises have been made. But there's some evidence, obviously, along the way that convinced the president and the people in the White House that she would fulfill his mission if she came to the Supreme Court. And when you look at the issues involved, it's not just her compassion when it comes to the Affordable Care Act and 23 million Americans covered by insurance under that law, 600,000 of them in Illinois. It's not just a question of her courage to stand up to this president if there's an election year contest that comes before the Supreme Court. It's really whether she's committed to the preserving the pillars of modern law, the rights of women. Ruth Bader Ginsburg's death created this vacancy. There's hardly a person in our history, modern history, who spent more of her life dedicated to the rights of women. Is Amy Coney Barrett going to follow in that tradition? I think it's a legitimate question. When it came to racism, are we going to deal with racism in an honest way? And I'll get to that in a moment when I speak to her originalism motivation. Marriage equality, privacy, voting. All these issues are on the table. And I do have to disagree with my colleague from Texas who preceded me. I just don't believe the law is robotic, nor do I believe that there is a simple formula to use that can guarantee an outcome in a case. As I said to Judge Barrett in our private conversation before the hearing, there wouldn't be 5 to 4 cases if we could count on people to always look at the facts in the law and come to the same conclusion. People reach different conclusions. And that takes me to the third point here. We asked Amy Coney Barrett during the course of this hearing so many questions about basic law that went right to the heart of this Constitution. These weren't trick questions. They weren't pending litigation. Questions like, can this president or any president unilaterally decide to change the date of the presidential election? That's pretty basic. I think it's covered by 3 different sections in this Constitution. She refused to answer because of the possibility that there would be litigation before the court on that subject. Well, what about intimidation against voters trying to cast their votes in an election? Couldn't answer that one either. Same reason. Well, what about, and this was asked by Senator Kennedy, Republican of Louisiana, what about climate change? Well, it turns out Judge Barrett told us she really hadn't developed any thoughts on climate change. Really? 48 years old, lawyer, law school professor, mother of 7, no thoughts on climate change? It really, when it was all over, you had to ask yourself, what was the purpose of that hearing if those were the kinds of answers we faced? Certainly we wouldn't ask her about pending litigation. But the one thing that she was very proud of and stated over and over again is that she was an originalist when it came to her thinking on the law and the Constitution. As I said, originalism is not some foreign language you pick up on Babbel. It's a mindset. It's a mission statement. It's the belief that the original text in our Constitution reveals all the answers. I doubt that very much. That's kind of MAGA jurisprudence. Take us back to the good old days of jurisprudence. Because you see, what really launched originalism occurred in the 1950s in a case called Brown versus Board of Education. The southern states were not ready for integration, and many of the northern states weren't either, for that matter. And the critics of that Supreme Court decision said it was judicial activism to integrate the public schools of America. They were critical of a court that went too far under Earl Warren, called for his impeachment and more, and started saying you should have stuck with the original Constitution. Well, the original Constitution didn't give African Americans the right to vote. In fact, considered them under the law to be 3/5 of an American citizen. And so those so-called originalists of that day, those textualists of that day, criticized that activist court, and it didn't end with Brown versus Board of Education. The same criticism was launched when it came to Griswold versus Connecticut, a case that really argued that we have a right of privacy in our married lives that can't be overcome by the state. Loving versus Virginia, that interracial marriage was permissible. And then, of course, the case of Roe versus Wade, the ultimate case when it came to privacy and liberty. So those who come before us and tell us that what's really at stake here is restraint on the court, self-discipline on the court, we've heard all those words, and making sure that justices don't pursue policy. Think about all of those things in terms of what happened in Brown versus Board of Education, when they overruled Plessy versus Ferguson of decades before and said, moving forward, we believe this Constitution guarantees to every child the right to an education, regardless of their race. Dr. Chemerinsky is with the University of California School of Law in Berkeley, wrote a recent article in the New York Times on this originalism theory. And he noted the fact that it was Anton Scalia who gave it great popularity. And a lot of people followed Scalia because he was cerebral, jocular, fun to be with. He spoke to a luncheon of Democratic senators that I was able to attend. But when it came down to it, his views of the law were pretty strict and pretty rigid, pursuing this idea that, for example, under this view, the First Amendment means the same thing as when it was adopted in 1791. 14th Amendment means the same thing as it was ratified in 1868. It turns out that the circumstances in all of those cases have changed so dramatically in America. Judge Amy Coney Barrett argued she's an originalist. She would be joining that other originalist on the court, Clarence Thomas, with her legal thinking. And that gives me pause and concern when it comes to what she's bringing to the court. A head full of law for sure, but an approach to it that I think is oppose. It is a way to argue against change and evolution in America that is inevitable and, in fact, necessary. Professor Chemerinsky says, in fact, under the original public meaning of the Constitution, it would be unconstitutional to elect a woman as president or vice president until the Constitution's amendment, because Article 2 refers to them with the pronoun he. When you get stuck with the language in the original Constitution in the extreme, you find yourself reaching conclusions that are not in the best interest or consistent with American mores or values today. So, Mr. President, this is more than just another nomination to fill a vacancy on the Supreme Court. It comes at a moment in time when we should be focusing on the deadly pandemic facing America. We should have spent 5 straight days coming up with a COVID relief bill for the millions of Americans desperate for help today and desperate for peace of mind when it comes to this public health tragedy which we're facing. It is a nomination which comes before us when the rules of the Senate and the rules of the Senate Judiciary Committee are being twisted and turned to create a political opportunity for Senator McConnell on his side of the aisle. And sadly, it is a moment in time when a nominee for the Supreme Court wants to bring to us a political way of thinking, a legal way of thinking, I should say, a legal way of thinking, which I believe is inconsistent with progress in this country when it comes to human rights and civil rights. Under originalist theory, we may never have had Brown versus Board of Education and the other cases I mentioned. What a loss for this great nation. That's not what we need on the court. We need people on the court who are realists, who will look at the law and the Constitution in real terms and not ideological terms. And the notion that this justice is being hurried before us in the hopes that she will eliminate the Affordable Care Act in the midst of a pandemic certainly is worth noting. It's one of the reasons, one of many of the reasons, that I'll be voting no on Amy Coney Barrett with her nomination to the Supreme Court, and I yield the floor.
Carolina. Thank you. As chairman of the Judiciary Committee, it's my honor to speak on the floor about this nomination, which I think is historic in many fashions, all positive from my point of view. We have on before the committee the nomination of Judge Barrett, who currently sits on the 7th Judicial Circuit. She is one of the most impressive people I've ever met. 2 days of hearings, answering every question thrown to her with grace and judicial demeanor, I think, should be the gold standard for every other nominee. But I want to thank my staff, Lee Holmes, the director. Lee's done such a great job of, the Judiciary Committee has done a lot of things, some contentious, some not, but I want to thank Lee for shepherding this nomination and the fine work he's done. Mike Fragozio, that's Mike, I got your first name right anyway, just outstanding. You've done a terrific job. The permanent nominations unit for the Judiciary Committee includes Laura Miller, Raja Churchill, Tim Rodriguez, Watson Horner, Akil, Ragasekar, don't want to butcher your name. All have worked incredibly hard for 135 Article 3 judges, not just this one. In addition, Lucas Croslow joined my staff to lead the team of special counsels assisting with the Barrett nomination. That included Sid D-A-D-H-I-C-H, Jay Favell, Abby Holstein, Eric Palmer, Robert Smith. They went through the entire record presented by Judge Barrett to make sure we would be prepared for the confirmation process. Law clerks Matt Simpson, Emily Hall, Megan Karen, and Peter Singal. I'd like to thank the Judiciary Committee's press secretary, Taylor Reed, did a great job, Taylor, along with George Hartzman, as well as by our Deputy Staff Director, Joe Keeley. Bottom line, all of them worked really hard. You made history. You should be proud. You can tell your grandkids about all this. Well done. To my Democratic colleagues, I know you didn't like what we did, but I do appreciate the way you conducted yourself in the hearing. It wasn't a circus. I think you challenged the judge appropriately during her time. We had 4 days of hearings. We heard from a variety of people about Judge Barrett. In terms of the process, it was well within what we've done in the past. Every Judiciary Committee markup regarding a Supreme Court justice, we've done the same thing. First day is opening statements, 2 days of questions, and the final day input from outside groups, and that's what we're able to do here. So she went through the process like every other nominee since I've been here. But let me just say this to my Democratic colleagues, it's not about the process. You find ways to make sure that most of you can't vote for anybody we nominate. And it really does break my heart. Robert, 78-22, that was sort of the norm. I think Alito got 96 and Ginsburg got 97. Maybe I got the numbers right. I can't remember who got what, but one got 96, one got 97. Used not to be this way, Senator Sullivan. Used to be different. We looked at the qualifications, said, okay, you're good to go. You're a person of integrity. You're smart. You're well-rounded. You're knowledgeable in the law. You may have a different philosophy than I have, but we understand elections matter. And everybody accepted the election outcome. Those days are over. Absolutely, completely over, destroyed. There's nobody any Republican president can ever nominate, I think, is not going to face a hard time. That's too bad. That's the way it is. Alito, 58-42. Judge Alito, well known on our side of the aisle, the kind of person you'd be looking at to promote to the Supreme Court. When President Bush nominated him, well within the mainstream. Robert Alito, well known in the conservative world of being very bright Court of Appeals judges that any Republican president would be looking at to put on the court if they ever had an opportunity. No difference between Alito and Roberts, but Alito went through hell, but he made it and he got 58 votes. So then along comes President Obama. He gets 2 picks, Sotomayor, 68 votes to 31. I think she deserved more, but 68 is pretty darn good. I was glad to vote for her. I saw that she was qualified. Then we had Elena Kagan, 63 votes. So you can see the trend here. Both of Obama nominees, 68-63. And I thought Elena Kagan was highly qualified, different judicial philosophy. She was a dean of law school at Harvard, but worked for the Solicitor General's office. Both of them have been with the liberal side of the court most every case, but not all. I'm not surprised with the way they've decided cases. I think they're tremendously well qualified women should be sitting on the court. That's exactly who you would expect a Democrat president to pick, Sotomayor and Kagan. So now we come back, Trump wins. Nobody thought he would win, including me. I voted for somebody in 2016. I wouldn't know if he walked through the door, Evan McMullen. I think I met him once. I had my challenge for President Trump during the 2016 primary. He beat me like a drum. I accepted my defeat. I've been trying to help him ever since, and I think he's done a really good job of sending to the Senate highly qualified judges. He's gotten input from a lot of different people, the Federalist Society, you name it, a lot of different people. Gorsuch and Kavanaugh have one thing in common. They were in my top 3 recommendations. Any Republican president looking to nominate somebody to the Supreme Court would be looking at Gorsuch and Kavanaugh. These are not exotic picks. They're in the mold of Sotomayor and Kagan in terms of qualifications. So what happened? Gorsuch was the first attempt at a partisan filibuster. We had 3 votes to get 60, and we couldn't, so we changed the rules for the Supreme Court like they changed the rules in 2013 for the District Court and Court of Appeals. If we had not, Gorsuch wouldn't be on the court, and to say he's not qualified is a joke, is an insult to him, and says more about you than it does Judge Gorsuch. If you can't see he's qualified, you're blinded by your hatred of Trump. So he made it, but we had to change the rules. Hated to do it, but had to do it because in any other time, Gorsuch would have gotten the same type votes as Roberts because he's just highly qualified. Then comes along Kavanaugh. Nothing about process there. There's no process argument. Right at the very end, the last day of the hearing, when we thought it was all over, you give us a letter that you'd had for weeks, an allegation against the judge. It'd been nice to share it with him so he could tell his side of the story, but you chose not to do that. You had it pre-cooked with the press outlets, and everything blew up. So all of us on the committee had to decide what to do. I sat down with Senator Flake and Senator Collins, and we felt like the allegations had to be heard. They're made. And I know a lot of people on our side thought it was unfair, dirty pool, but we had the opportunity to have the hearing. And the rest is history. It was high drama. All I can say that something happened to the person who accused Judge Kavanaugh, but I don't believe Judge Kavanaugh had anything to do with it. This was a party in high school. Dr. Ford couldn't remember where it was, who was there. The people that were said to be there said they don't remember anything like it happened. Judge Kavanaugh hasn't lived a life like being described. He was accused by 4 or 5 people. 3 of them actually made it up. I hope some of them go to jail for lying to the committee in the country. And they were trying to make him a rapist and drugging women in high school. And what was his annual all about? It was the most sickening episode in my time in the Senate. They were hell-bent on destroying this guy's life based on a bunch of manufactured lies and evidence that wouldn't get you out of the batter's box in any court of law in the land. And here we are, 50 to 48. And what I saw there was a turning point for me. We cannot continue to do this. You're going to drive good people away, and I'm hoping that the Barrett hearings, which were far more civil, far more traditional, will be a turning point. Because I don't know who the next president will be, but there'll be an opening, I'm sure, in the court. I'm hoping that the next hearing is more like Barrett and less like Kavanaugh, no matter who wins. Now, Barrett, I understand the concern about the process. This is the latest we've ever confirmed somebody. You've heard all the arguments about when the presidents of one party and the senates of a different party. You've had one confirmation in 100 and something years. that most of the time when the presidents of the same party as the Senate, they go through. I understand. The bottom line is we gave her the same type hearing that Alito, Sotomayor, Kagan, Gorsuch, and Kavanaugh had. My Democratic colleagues showed up at the hearing. They participated. They pushed her hard, but I don't think they went across the line. They decided not to show up to markup. I hate that, but that's the way it is. I would like to spend a few minutes talking about the person who's going on the court in about an hour. If you're looking for somebody that a Republican would be picking, regardless of the process, it would be Judge Barrett. She would be on anybody's list. And I listened to Senator Durbin, who is a good friend, and we'll work on whatever comes our way after the election. I find that he's somebody you can work on hard things like immigration with, but his description of Judge Barrett simply doesn't pass scrutiny. Trying to make a character of this person that doesn't exist. There's nothing exotic about Judge Barrett. She's very mainstream in our world. All I can say is that after 2 days of hearings, the American people, by 51%, which is pretty hard to figure in this country, you get 51% agreement on anything, felt like she should be going on the court. So here's what Dean O'Hara said, Dean of Notre Dame Law School, who hired Amy Barrett to be a professor at Notre Dame. I have only communicated with this august committee on 2 occasions. The first was 10 years ago when I wrote a strong letter in support of now Justice Elena Kagan, whose term as Dean of Harvard Law School overlapped with my own. The second is today, introducing and endorsing Amy Coney Barrett in equally strong terms. Some might find these recommendations to be in juxtaposition, but I find them entirely consistent. And to anybody wondering about Judge Barrett, I would highly recommend that you look at the ABA's recommendations and the process they used to find her well qualified. Not one person uttered a negative word about her character, according to the ABA. Someone said to the ABA, the myth is real. She is a staggering academic mind. She is incredibly honest and forthright. She's exactly who you think she is. Nothing about her is fake. She is good, she's decent, she's selfless, she's sincere. She's an exemplary of a living and integrated life. The standing committee would have been hard-pressed to come up with any conclusion other than that Judge Barrett has demonstrated professional competence that is exceptional. Then they had a committee to look at her writings, all of her writings. They accepted input from 944 people that she's interacted in her professional life, not one negative comment. So forget about what politicians say about Judge Barrett. Forget about what people who don't recognize President Trump as being a legitimate president say about Judge Barrett. Forget about what I say if you want to. Look at what people who work with her said that are in the law business, that know her individually, have worked with her as a judge, as a professor, and they conclude without any doubt she is one of the most gifted people to ever be nominated to the Supreme Court. There's nothing exotic about Judge Barrett. She's going on to the court in about an hour. That's exactly where she needs to be. She's the type person who's lived a life worthy of being nominated. She's the type person that's worthy of receiving a large vote in the Senate, but she won't get it. She's not going to get one Democratic vote. And you're right off the process if you want to. That's fine. But what about the others? All I can say is that we're going to have an election here in about a week. And whatever happens, I'm going to acknowledge the winner when it's all said and done. It may go to the Supreme Court, I don't know. But there'll be a day that we know who won. And I'm going to accept those results, and I'm going to do with the next president what I've tried to do with this one and every other one. Try to find a way forward on things that are hard, keep the country moving forward. So to the majority leader and the minority leader, it's a tough place around here now. This too shall pass. But this is about Judge Barrett. This is about her time, her moment. She's done everything you would expect of her. She's exceeded every challenge put in her way. She's impressed everybody she's worked with. She has impressed the country. She's going onto the court because that's where she deserves to be. As to us in the Senate, maybe down the road we can get back to the way we used to be. I don't know, but I do know this. There's nothing exotic about Judge Barrett. She's as mainstream as it gets from our side of the aisle. And when it comes to people outside of politics looking at her, it was universal, highly qualified, highly competent, ready to serve this country as Social Justice of the Supreme Court. And my last thought, it's hard to be a conservative person of color. That is a very difficult road to hoe in a modern American politics. My good friend Tim Scott is a great voice of conservatism. And Tim, a lot of things said about Tim, it's said about nobody else on our side of the aisle. And he's tough, he can handle it. Same for conservative women. Judge Barrett did not abandon her faith. She embraces it, but she said, I embrace my faith, but as a judge, it will not be the rule of Amy. It will be the rule of law. It will be the facts. It will be the law, an outcome dictated by the law, not by anything I personally believe. But I will say this, for the young conservative women out there who are pro-life and embrace your faith, there's a seat at the table for you. This is historic. This nomination is different. This is a breakthrough for conservative young women. And I was honored to be the chairman of the committee that reported out Judge Barrett to the floor of the Senate. And I'm going to be honored to cast my vote to put her on the Supreme Court exactly where she deserves to be. I yield.
Mr. President.
Minority Leader.
Today, Monday, October 26, 2020, will go down as one of the darkest days in the 231-year history of the United States Senate. Let the record show that tonight, the Republican Senate majority decided to thwart the will of the people and confirm a lifetime appointment to the Supreme Court in the middle of a presidential election after more than 60 million Americans have voted. Let the record show that tonight, the Republican majority will break 231 years of precedent and become the first majority to confirm a Supreme Court justice this close to Election Day. And let the record show that tonight, the Republican majority will make a mockery of its own stated principle that the American people deserve a voice in the selection of Supreme Court justices, completing the partisan theft of 2 seats on the Supreme Court using completely contradictory rationales. And let the record show that the American people, their lives and rights and freedoms, will suffer the consequences of this nomination for a generation. This entire debate can be summed up in 3 lies propagated by the Republican majority and one great, terrible truth. The first lie is that the Republican majority is being consistent in following its own standard. What rubbish. After refusing a Democratic nominee to the Supreme Court because an election was 8 months away, they will confirm a Republican nominee before an election that is 8 days away. What's Leader McConnell's excuse? He claims that the principle of not confirming justices in presidential years only applies when there's divided government. But this is what Leader McConnell said after Justice Scalia died. The American people should have a voice in the selection of their next Supreme Court justice. That's all he said. He didn't say that the American people should have a voice, but only when there's divided government. No, the last bit is ex post facto. If this were really about divided government all along, Republican senators would not have promised on the record to follow their own standard if the situation was reversed. I want you to use my words against me, said the chairman of the Judiciary Committee. If there's a Republican president in 2016 and a vacancy occurs in the last year of the first term, you can say Lindsey Graham said, let the next president, whoever it might be, make that nomination. So the claim by the leader that this is consistent with their own principle, please. Rather than accept the consequences of its own words and deeds, the Republican majority is lighting its credibility on fire. This hypocritical 180-degree turn is spectacularly obvious to the American people. The second lie is that the Republican majority is justified because of Democratic actions on judicial nominations in the past. The Republican leader claims that his majority's actions are justified by all the bad things Democrats did years ago. He claims that every escalation of significance in judicial debates was made by Democrats. But in his tortured, convoluted history lesson, Leader McConnell left out a whole bunch of chapters. He omitted that Republicans bottled up more than 60 judicial nominees by President Clinton, refusing them even a hearing. He made no reference to the decision by Republican senators to hold open 14 appellate court seats in the 1990s so that a Republican president could fill them. Instead, a tactic Republicans would revisit under President Obama when Republicans used partisan filibusters to block his nominees to the D.C. Circuit. At the time, Republican senators, including my colleague from Kentucky, amazingly accused President Obama of trying to pack the court by the mere act of nominating judges to vacancies of the Second Circuit. What a hypocritical double standard, which appears to be endemic in Leader McConnell's recounting of history. And on top of it all, the leader has asked the Senate to play a blame game that dates all the way back to 1987, pointing to a 3-minute speech by Senator Kennedy about Robert Bork as the original sin in the judicial wars. Seriously, that's what he said. Because one Democrat gave one 3-minute speech that Republicans didn't like, Leader McConnell can steamroll the minority to confirm a justice in the middle of election. Imagine trying to explain to someone, sorry, I have to burn down your house because of something one of your friends said about one of my friends 33 years ago. That's how absurd and obnoxious this game has gotten. That's how unjustifiable the majority's actions are, how flimsy their excuses have become. The leader's final argument boils down to, but you started it, a declaration you'd sooner hear in the schoolyard than on the floor of the United States Senate. And the third, and perhaps the greatest lie, is that the Republican majority is confirming Judge Barrett solely on the basis of her qualifications, not based on her views on the issues. My colleagues insist that Judge Barrett should be confirmed on her credentials alone. That's all they talk about. They don't talk about her views on the issues, only qualifications. Well, this canard is about as apparent as a glass door. Everyone can see right through it. What's the real reason Republicans are so desperate to rush Judge Barrett onto the Supreme Court? Of course it's not because of her qualifications. If my Republican friends truly believed that the only thing that mattered about a judicial candidate is their qualifications, then Merrick Garland would be sitting on the Supreme Court right now. If the Republican leader truly believed that judicial appointments were about qualifications and qualifications alone, Judge Garland would be Justice Garland right now. Judge Garland was among the most qualified candidates ever to be nominated to the Supreme Court. No Republican senator has disputed that. But they didn't want Judge Garland on the bench. They do want Judge Barrett. They subjected Judge Garland to an unprecedented partisan blockade. But they're erecting a monument to hypocrisy to rush Judge Barrett onto the bench. Why? It's not because she's more qualified than Judge Garland was. What's the difference between Barrett and Garland? The difference is not qualifications, but views. We know that. We all know that. Health care, a woman's rights, a woman's right to choose, gun safety, you name it. It's not because the far right wants Judge Barrett's views on the court, but it's because the far right wants Judge Barrett's views on the court, but not Judge Garland's. The truth is, this nomination is part of a decades-long effort to tilt the judiciary to the far right, to accomplish through the courts what the radical right and their allies, Senate Republicans, could never accomplish through Congress. Senate Republicans failed to repeal the Affordable Care Act, so President Trump and Republican attorneys general are suing to eliminate the law in court. Republicans would never dare drive that right to the point of near extinction and then provoke the Supreme Court to review Roe v. Wade. The far right has never held a majority on the court to limit Roe v. Wade or Griswold, but if Judge Barrett becomes Justice Barrett, it very well might. And if you're looking for some hard numbers to prove that the political right considers ideology and not just qualifications, consider this. Under Justice Roberts, there have been 80 cases, 80, decided by a 5-4 majority, in which the 5 justices nominated by Republican presidents came down on one side, and the 4 justices nominated by Democratic presidents came down on the other. 80 cases, exactly the same majority, calling balls and strikes, and in an amazing coincidence, all the Republican nominated justices think it's a strike, and all the Democratic ones think it's a ball, or vice versa. It would be the most remarkable coincidence in the history of mathematics if 9 justices, simply calling balls and strikes, exhibited the same split in the exact same configuration 80 times. We all know what the game is here, so stop pretending. Stop pretending there aren't entire organizations dedicated to advancing far-right judges. Stop pretending that the political right doesn't spend millions of dollars to prop up the far-right Federalist Society and support certain judicial candidates because they only want qualified judges. No, they want to systematically and permanently tilt the courts to the far right. So does Judge Barrett have views on legal issues? You bet she does. And that brings me to the one great and terrible truth about this nomination. The American people will suffer the consequences of Judge Barrett's far right, out of the mainstream views for generations. Judge Barrett came before the Judiciary Committee and refused to answer nearly any question of substance. That's the new game at the hearings. She would not answer questions about health care. She would not say whether voter intimidation is illegal. She would not say if she thought Medicare and Social Security were constitutional. She could not even offer platitudes in responses to questions about the peaceful transfer of power, and refused to say if climate change was real. It's not because Judge Barrett isn't allowed to answer these questions. It's because she knows how unfavorable her views on the issues might sound to the American people. But the thing is, we do know how Judge Barrett thinks. She views certain rights, like the right to privacy, through a pinhole. She was closely affiliated with organizations who advocated the outright repeal of Roe v. Wade. But she views other rights, like the right to keep and bear arms, as almost infinitely expansive. She once authored a dissent arguing the federal government does not have the authority to ban all felons from owning guns. Only a few hours ago, the Republican senator from Missouri proudly declared from the Senate floor that Judge Barrett is the most openly pro-life judicial nominee to the Supreme Court in his lifetime. Quote, "This is an individual," he said of Judge Barrett, "who has been open in her criticism of that illegitimate decision, Roe v. Wade." He was being more honest than most of the talk around here, which says it's only about qualifications. Judge Barrett has proudly fashioned herself in the mold of her mentor, Justice Scalia, who before his death appeared set to declare union fees to be unconstitutional, driving a stake into the heart of the American labor movement. While American workers break their back to make ends meet and earn ever less of ever-growing corporate profits, what might Justice Scalia's former clerk portend for the future of labor rights? What about voting rights? Judge Barrett has suggested that certain rights are civic rights, including voting rights, and can be restrained by the government. But other rights, like the right to keep and bear arms, are individual rights that cannot be subject to even the most common sense restrictions. And of course, what about health care? Judge Barrett has argued that Justice Roberts got it wrong when he upheld the Affordable Care Act. She said that if Justice Roberts read the statute properly, the Supreme Court would have had to invalidate, her words, the law. That's the same thing, by the way, that Donald Trump said about Justice Roberts and the ACA. That's the great and terrible truth about this nomination. Judge Barrett holds far-right views well outside the American mainstream, and those views matter to the vast majority of Americans. They matter to women facing the hardest decision of their lives. They matter to LGBTQ Americans like my daughter, who only 5 years ago won the legal right to marry who she loves and could lose it just as fast. They matter to little girls like 7-year-old Penny Feynman from West Hempstead, Long Island, born with a neurological disorder, bound to a wheelchair, attached to a feeding tube, who is alive today, because of the Affordable Care Act. We're talking about the rights and freedoms of the American people, their right to affordable health care, to make private medical decisions with their doctors, to join a union, to vote without impediment, to marry who they love and not be fired because of who they are. Judge Amy Coney Barrett will decide whether all those rights will be sustained or be curtailed for generations. And based on her views on the issues, not on her qualifications, but her views on the issues, Judge Barrett puts every single one of those fundamental rights, American rights, at risk. So I want to be clear with the American people. The Senate majority this Republican Senate majority is breaking faith with you, doing the exact opposite of what it promised 4 years ago, because they wish to cement a majority on the Supreme Court that threatens your fundamental rights. And I want to be very clear with my Republican colleagues. You may win this vote, and Amy Coney Barrett may become the next Associate Justice of the Supreme Court. But you will never, never get your credibility back. And the next time the American people give Democrats a majority in this chamber, you will have forfeited the right to tell us how to run that majority. You may win this vote, but in the process, you will speed the precipitous decline of faith in our institution, our politics, the Senate, and the Supreme Court. You will give an already divided and angry nation a fresh outrage and open a wound in this chamber that will take a very long time to heal. You walk a perilous road. I know that you think that this will eventually blow over, but you're wrong. The American people will never forget this blatant act of bad faith. They will never forget your complete disregard for their voices, for the people standing online right now and voting their choice, not your choice. They will never forget the lack of consistency, honor, decency, fairness, and principle. They will never forget the rights that are limited, constrained, or taken away by a far-right majority on the Supreme Court. And history will record that by brute political force, in contradiction to its stated principles, this Republican majority confirmed a lifetime appointment on the eve of an election. A justice who will alter the lives and freedoms of the American people while they stood in line to vote. Leader McConnell has lectured the Senate before on consequences of a majority's action. You'll regret this, he told Democrats once, and you may regret this a lot sooner than you think. Listen to those words. You'll regret this, and you may regret it a lot sooner than you think. I would change just one word. My colleagues may regret this for a lot longer than they think. Here, at this late hour, at the end of this sordid chapter in the history of the Senate, the history of the Supreme Court, my deepest and greatest sadness is for the American people. Generations yet unborn will suffer the consequences of this nomination. As the globe gets warmer, as workers continue to fall behind, as unlimited dark money floods our politics, as reactionary state legislatures curtail a woman's right to choose, gerrymander districts, and limit the rights of minorities to vote, my deepest, greatest, and most abiding sadness tonight is for the American people and what this nomination will mean for their lives, their freedoms, their fundamental rights. Monday, October 26th, 2020, it will go down as one of the darkest days in the 231-year history of the United States Senate. I yield the floor.
Mr. President.
Majority Leader.
I think my remarks may encroach somewhat on the time previously set for beginning the vote. I ask consent that I be allowed to finish.
Without objection.
Well, this evening, the Senate will render one of the most consequential judgments it can ever deliver. We will approve a lifetime appointment to our nation's highest court. Since the ink dried on the Constitution, only 114 men and women have been entrusted to uphold the separation of powers, protect people's rights, and dispense impartial justice on the Supreme Court. In a few minutes, Judge Amy Coney Barrett of Indiana will join their ranks. This body has spent weeks studying the nominee's record. We've examined 15 years of scholarly writings, about 100 opinions from the Seventh Circuit, and testimonials from legal experts running the gamut from close colleagues to total strangers. There have been one-on-one meetings for every senator who wanted one, and a week of intensive hearings. All of it has pointed to one conclusion. This is one of the most brilliant, admired, and well-qualified nominees in our lifetime. Intellectually, Judge Barrett is an absolute all-star. She graduated #1 in her class at Notre Dame Law School. She clerked on the second highest federal court and the Supreme Court. Then she returned to her alma mater and became an award-winning academic. Judge Barrett's mastery of the Constitution gives her a firm grasp on the judicial role. She's pledged to apply the law as written, not as she wishes it were. Her testimony, her writings, and her reputation confirm a total and complete commitment to impartiality. And the nominee's personal integrity and strength of character are literally beyond reproach. She earned the highest rating from the left-leaning American Bar Association. They marveled at, quote, breadth, diversity, and strength of the positive feedback they received from judges and lawyers of all political persuasions. If confirmed, this daughter of Louisiana and Indiana will become the only current justice with a law degree from any school not named Harvard or Yale. Any school not named Harvard or Yale. She'll be the first mother of school-aged children to ever sit on the court. By every account, the Supreme Court is getting not just a talented lawyer, but a fantastic person. We've heard moving testimony from former students whom Judge Barrett went out of her way to help and to mentor. Her past clerks describe an exemplary boss. Her fellow scholars describe a winsome, respectful colleague who is tailor-made for the collaborative atmosphere of the court. By any objective standard, colleagues, Judge Barrett deserves to be confirmed to the Supreme Court. The American people agree. In just a few minutes, she'll be on the Supreme Court. 2 weeks ago, a CNN journalist made this observation that I found particularly interesting. Here's what he said: let's be honest. In another political age, Judge Amy Coney Barrett would be getting 70 votes or more in the U.S. Senate because of her qualifications in a different era. Now, we know that's not going to happen. These are not the days when Justice Scalia was confirmed 98-0 and Justice Ginsburg was confirmed 96-3. And by the way, I voted for both Ginsburg and Breyer. Seems like a long time ago now. We spent a lot of energy in recent weeks debating this matter, 30 or so years. Each side feels the other side struck first and struck worst and has done more to electrify the atmosphere around here about confirmations. Now, predictably enough, I think our account is based on what actually happened, what actually occurred, factually accurate. I was there. I know what happened. I've laid it out earlier, and I'll talk about some of it again so the American people may understand how we got to where we are. It was the Senate Democrats, our colleagues over here, who amazingly enough don't seem to be on the floor at the moment, who spent the early 2000s boasting about their brand new strategy of filibustering qualified nominees from a Republican president. They were proud of it. They found a new way to halt the process, stop those crazy right-wing judges that Bush 43 was going to send up. They pioneered it because they knew what the precedent was at that point. At that point, as we discussed before, it just wasn't done. Oh, you could do it. You could, but you didn't. And the best evidence that you shouldn't do it was the Clarence Thomas nomination, confirmed 52 to 48. And all of us know that any one of us in this body has a lot of power to object. So if any one of the 100 senators at that time, including people who were virulently opposed to Justice Thomas, like Joe Biden and Ted Kennedy, could have made us get 60 votes and Clarence Thomas would not have been on the Supreme Court. That's how strong the tradition was until the Democratic leader led the effort in the early 2000s to establish the new standard. Well, after establishing a new standard, they got kind of weary of it, and in 2013, the so-called nuclear option was implemented because Republicans were holding President Obama's nominees to the same standard that they themselves had created. So when the shoe got on the other foot, they didn't like it too much. It was too tight. Senate Democrats, both in 1992 and 2007, helpfully volunteered how they would have dealt with a nominee like we did in 2016. The then chairman of the Judiciary Committee, Joe Biden, helpfully volunteered in 1992 when Bush 41 was running for re-election that had a vacancy occurred, they wouldn't fill it. There wasn't a vacancy, but he just helpfully volunteered how they would deal with it if they had one. If there's a vacancy, won't fill it. Well, to one-up him, Leader Harry Reid and his friend, now the Democratic leader, Chuck Schumer, said 18 months before the end of the Bush 43 period, if a vacancy on the Supreme Court occurred, they wouldn't fill it. That's a fact. What we're talking about here are the facts about how we got to where we are. I understand my Democratic friends seem to be terribly persuaded by their version of all of this. All I can tell you is I was there, I know what's happening, and my version is totally accurate. The truth is, on all of this, we owe the country a broader discussion. Competing claims about Senate customs cannot fully explain where we are. Procedural finger-pointing does not explain the torrent of outrage and threats which this nomination and many previous ones have provoked from the political left. There are deeper reasons why these loud voices insist it is a national crisis. You just heard it. It's a national crisis when a Republican president makes a nominee for the Supreme Court. Catastrophe looms right around the corner. The country will be fundamentally changed forever when a Republican president makes a Supreme Court nominee. They've hauled out the very same tactics for 50 years. 50 years. Some of the opposition is more intense, but the doomsday predictions about the outcome of nominating these extremists like John Paul Stevens, David Souter, I mean, the country was hanging in the balance? Really? Well, somehow everyone knows in advance that nominations like Bork, Thomas, Alito, Gorsuch, Kavanaugh, and Barrett are certain to whip up national frenzies, while nominations like Ginsburg, Breyer, Sotomayor, and Kagan are just calm events by comparison. This glaring asymmetry predates our recent disputes. And it comes my colleagues from a fundamental disagreement on the role of a judge in our republic. We just have a fundamental difference of opinion. We just heard the Democratic leader name all of these things that are threatened by this nominee. Sound very similar to the tunes we've heard before. Well, we, like many Americans, want judges to fulfill the limited role the Constitution assigns to them. Stick to text, resolve cases impartially, and leave policymaking to the people and their representatives, which is what we do here. We just spent 4 years confirming brilliant, qualified constitutionalists to the Supreme Court and lower courts who understand their roles. 53 circuit judges, over 200 judges in total, and we're about to confirm the third Supreme Court justice. What they all have in common: brilliant, smart, and know what a judge is supposed to be. But the left thinks the framers of our country got this all wrong. They botched the job. The people who wrote the Constitution didn't understand what a judge ought to be. Several Senate Democrats have reaffirmed in recent days during this discussion. They actually find it quaint or naive to think a judge would simply follow the law. Quaint or naive. Scalia used to say, if you want to make policy, why don't you run for office? That's not what we do here. Gorsuch said we don't wear red robes or blue robes, we wear black robes. What they want is activist judges. They've made it quite clear. The Democratic leader just a few minutes ago had made it quite clear. So what they're looking for here is a small panel of lawyers with elite educations to reason backward from outcomes and enlighten all the rest of us. Enlighten all the rest of us with their moral and political judgment. Whether the Constitution speaks to the issue or not. They know best what's for us. No matter what the Constitution or the law may say. And, you know, for the last several decades, in many cases, that's what they've gotten. One activist decision after another, giving the subjective preferences of one side the force of law. Across a variety of social, moral, and policy matters, like a healthy society would leave to democratic debate, the personal opinion of judges have superseded the will of the people. Now, they call that a success, and they want more of it. President Obama actually was refreshingly honest about this. He said he wanted to appoint judges who had empathy. Well, think about that for a minute, colleagues. What if you're the litigant before the judge for whom the judge does not have empathy? You're in tough shape. You're in tough shape. So you give them credit for being pretty honest about this. That's what they're looking for. The smartest leftish people they can put to make all the decisions for the rest of us, rather than leaving it to the messy democratic process to sort these things out the way the framers intended. And that is why, it's clearly why we have taken on such an outsized, combative atmosphere with regard to these confirmations. That's why they've become so contentious. Because they want to control not only the legislative body, but the judicial decisions as well. Let me just say this. There's nothing innate about legal training that equips people to be moral philosophers. There's just nothing inherent in legal training that equips people to be moral philosophers. And incidentally, as I just said, that's why these confirmations have taken on such an outsized, unhealthy significance. The remarks we just heard from across the aisle show exactly why the framers wanted to stop the courts from becoming clumsy, indirect battlefields for subjective debates that belong in this chamber and over in the House and in state legislatures around the country. The left does not rage and panic at every constitutional judge because they will simply enact our party's policy preferences. Any number of recent rulings make that very clear. The problem that every judicial seat occupied by a constitutionalist is one fewer opportunity for the left to go on offense. For the left to go on offense. At the end of the day, this is a valid debate. The difference of opinion on the judicial role is something the Senate and our system are built to handle. But there's something else, colleagues, our system cannot bear. As you've heard tonight, we now have one political faction essentially claiming they now see legitimate defeat as an oxymoron. They now see legitimate defeat as an oxymoron. Our colleagues cannot point to a single Senate rule that's been broken, not one. They made one false claim about committee procedure, which the parliamentarian dismissed. The process comports entirely with the Constitution. We don't have any doubt, do we, that if the shoe was on the other foot, they'd be confirming this nominee. And have no doubt, if the shoe was on the other foot in 2016, they'd have done the same thing. Why? Because they had the elections that made those decisions possible. The reason we were able to make the decision we did in 2016 is because we had become the majority in 2014. The reason we were able to do what we did in 2016, 2018, and 2020 is because we had the majority. No rules were broken whatsoever. So all of these outlandish claims are utterly absurd. And the louder they scream, the more inaccurate they are. You can always tell that. Just check the decibel level on the other side. The higher it goes up, the less accurate they are. Our Democratic colleagues keep repeating the word illegitimate, as if repetition would make it true. If you just say it often enough, does it make it true? I don't think so. We're a constitutional republic. Legitimacy does not flow from their feelings. You know? Legitimacy is not the result of how they feel about it. You know, you can't win them all, and elections have consequences. And what this administration and this Republican Senate has done is exercise the power that was given to us by the American people in a manner that is entirely within the rules of the Senate and the Constitution of the United States. Irony, indeed. Think about how many times our Democratic friends have said, been berating President Trump for allegedly refusing to accept legitimate outcomes he does not like. How many times have we heard that? President Trump won't accept outcomes he does not like. Well, they're flunking that very test right before our eyes. That's their problem. They don't like the outcome. Well, the reason this outcome came about is because we had a series of successful elections. One of our two major political parties increasingly claims that any political system that deals them a setback is somehow illegitimate. And this started actually long before this vacancy, as we all know. 1 year ago, Senate Democrats sent the court, directly, an amicus brief that read like a note from a gangster film. They wrote, "The Supreme Court is not well," in their amicus brief. The Supreme Court is not well. Perhaps the court can heal itself before the public demands it be restructured. In March of this year, the Democratic leader stood outside the court, went over in front of the court, and threatened multiple justices by name. Here's what he said: "You won't know what hit you if you go forward with these awful decisions. You will pay the price." That's the Democratic leader of the Senate in front of the Supreme Court, mentioning justices by name, and in effect saying, if you rule the wrong way, bad things are going to happen. For multiple years now, Democrats in this body and on the presidential campaign stump have sought to revive the discredited concept of court packing. Every high school student in America learns about Franklin Roosevelt's unprincipled assault on judicial independence. So now they're thinking about repeating it. Former Vice President Biden, who spent decades condemning the idea here in the Senate, obediently says he'll look into it. Most importantly, the late Ruth Bader Ginsburg said last year, when asked about this, she said 9 is the right number. That's the vacancy we're filling right now. I don't think any of them have quoted her on this issue lately, have you? Ruth Bader Ginsburg said 9 is the right number. These latest threats follow decades of subtler attempts to take independent judges and essentially put them on political probation. If you don't rule the way I want, something dire might happen. How many consecutive nominees have Democrats and the media insisted would, quote, tip the balance of the court? How often do we hear that? Tip the balance of the court. Has anyone tallied up how many hard right turns the courts have supposedly taken in our lifetimes? All this ominous talk is a transparent attempt to apply improper pressure to impartial judges. Rule how we want, or we're coming after the court. Rule how we want, or we're coming after the court. Vote how we want, or we'll destroy the Senate by adding new states. These have been the Democratic demands. This is not about separation of powers. It's a hostage situation. A hostage situation. Elections come and go. Political power is never permanent, but the consequences could be cataclysmic if our colleagues across the aisle let partisan passions boil over and scorch the ground rules of our government. The framers built the Senate to be the nation's firewall. Over and over, this institution, our institution, has stood up to stop recklessness that could have damaged our country forever. So tonight, colleagues, we're called on to do that again. Tonight, we can place a woman of unparalleled ability and temperament on the Supreme Court. We can take another historic step toward a judiciary that fulfills its role with excellence, but does not grasp after power that our constitutional system intentionally assigns somewhere else. And we can stand loud and clear that the United States Senate does not bow to intemperate threats. Voting to confirm this nominee should make every single senator proud. So I urge my colleagues to do just that.
Clerk will call the roll.
Mr. Alexander. Present. Ms. Baldwin. Mr. Barrasso. Present.
A quorum is present. Can I read? All post-cloture time has expired. The question occurs on the nomination of Amy Coney Barrett of Indiana to be Associate Justice of the Supreme Court of the United States. A senator. Is there a sufficient second? There is a sufficient second. The clerk will call the roll.
Mr. Alexander. Aye. Ms. Baldwin. No. Mr. Barrasso. Aye. Mr. Bennett. Mrs. Blackburn. Aye. Mr. Blumenthal. No. Mr. Blunt. Aye. Mr. Booker. No. Mr. Bozeman. Aye. Mr. Braun. Aye. Mr. Brown. No. Mr. Burr. Ms. Cantwell. No. Mrs. Capito. Mr. Cardin. No. Mr. Carper. No. Mr. Casey. No. Mr. Cassidy. No. Ms. Collins. Mr. Coons. Mr. Cornyn. Aye. Ms. Cortez Masto. Mr. Cotton. Aye. Mr. Kramer. Aye. Mr. Crapo. Aye. Mr. Cruz. Aye. Mr. Daines. Aye. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Aye. Ms. Ernst. Aye. Mrs. Feinstein. Mrs. Fisher. Aye. Mr. Gardner. Aye. Mrs. Gillibrand. No. Mr. Graham. Aye. Mr. Grassley.
Aye.
Ms. Harris. Ms. Hassan. No. Mr. Hawley. Aye. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Aye. Mr. Jones. Mr. Kane. Mr. Kennedy. Aye. Mr. King. No. Ms. Klobuchar. Mr. Langford. Aye. Mr. Leahy. Mr. Lee. Aye. Mrs. Leffler. Aye. Mr. Manchin. Mr. Markey. No. Mr. McConnell. Ms. McSally. Aye. Mr. Menendez. Mr. Merkley. Mr. Moran. Aye. Ms. Markowski. Aye. Mr. Murphy. Mrs. Murray. Mr. Paul. Aye. Mr. Perdue. Aye. Mr. Peters. No. Mr. Portman. Aye. Mr. Reed. Mr. Risch. Aye. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema, Ms. Smith, Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young. Senators voting in the affirmative: Alexander, Barrasso, Blackburn, Blunt, Bozeman, Braun, Burr, Capito, Cassidy, Cornyn, Cotton, Kramer, Crapo, Cruz, Daines, Enzi, Ernst, Fisher, Gardner, Graham, Grassley, Hawley, Hoeven, Heidsmith, Inhofe, Johnson, Kennedy, Lankford, Lee, Loeffler, McConnell, McSally, Moran, Murkowski, Hall, Perdue, Portman, Risch, Roberts, Romney, Rounds, Rubio, Sass, Scott of Florida, Scott of South Carolina, Shelby, Sullivan, Thune, Tillis, Toomey, Wicker, Young. Senators voting in the negative: Baldwin, Blumenthal, Booker, Brown, Cantwell, Cardin, Carper, Casey, Collins, Coons, Cortez Masto, Duckworth, Durbin, Feinstein, Gillibrand, Harris, Hassan, Heinrich, Hirono, Kane, King, Klobuchar, Leahy, Manchin, Markey, Merkley, Murphy, Murray, Peters, Rosen, Sanders, Schumer, Shaheen, Sinema, Smith, Van Hollen, Warner, Warren, Whitehouse, Wyden. Mr. Menendez, no. Mr. Schatz, no. Mr. Reed, no. Ms. Stabenow. Ms. Stabenow, no. Mr. Bennett. Mr. Bennett, no. Mr. Jones, no. Mr. Udall. Mr. Udall, no.
Senate will come to order. Are there any senators in the chamber who wish to vote or change their vote? If not, on this vote, the yeas are 52, the nays are 48. The nomination of Coney Barrett of Indiana to be an Associate Justice of the Supreme Court of the United States is confirmed.